Well, good morning, everybody. It's 11:30. I'm Jeff Rosen. I'm one of the attorneys here at the firm. I'm joined by the owner of our firm, Jim Cunningham. Hey, Jim, how are you?
Hey, good morning, Jeff. How you doing?
Doing great. So thanks to all of you for joining us. I think we have a fantastic virtual workshop for you today. We are going to be talking about just who owns the house. We're going to clear up the confusion. So Jim, I don't know about you, but I have people come in to meet with me all the time regarding their estate plan, and they own real estate. And frankly, they have no idea how it's titled, or maybe they know how it's titled, but they don't understand the significance of that, right? What does it mean to own something as joint tenants or community property or separate property? So our goal today is to unravel this for you guys. We're gonna probably speak for about 45 minutes on this topic. If you have any questions, you can feel free to put them in the Q&A section. You can put them on the chat section. But Jim, I'm really, really excited about this particular webinar. I think this is a topic that a lot of people are wondering about. So I'm glad you could join us. Thanks a lot.
Yeah, this is super, super important because, law, the reason there are lawyers is this stuff can get pretty complicated. What seems simple can be really complicated. And one of the things that we're going to talk about is if somebody gets married and they own a piece of property with a mortgage and they make the payments during marriage. Well, who owns the house? That's a really important question. One person's name may be on title, but that's not the whole story. So we're going to talk about that. So you ready to get started, Jeff?
Yeah, absolutely. But before we actually start talking about legal stuff, Jim, since we're lawyers and since we're talking about legal stuff, we're required to put this disclaimer up here. So just so everybody knows, we are, the purpose of our meeting today is really to get the brain juices flowing. It's really to look at these topics from a 30,000-foot level. And so what Jim and I don't want you guys to do is at the end of the presentation, go off and retitle your property on your own or do something without the advice of an attorney. So speaking of advice from an attorney, what we're offering all of you guys for joining us today is the opportunity at the end of this presentation to schedule at a time that's convenient for you a free, no obligation consultation with me or one of the other lawyers at the firm. It's a fantastic opportunity, and I encourage all of you to take us up on it. Now, I always like to start this off by identifying what gets you into trouble, right? Because our job as lawyers is to keep the people we work with out of trouble, right? So what actually gets people into trouble? Well, what you know isn't necessarily what gets you into trouble. What you know don't still doesn't get you into trouble. It's really what you don't know that gets you into trouble, folks. And our goal today is to shrink that window of what you don't know so that you yourself don't get into trouble. Now, as we alluded to at the very beginning, there are a bunch of different ways you can title property. And the legal significance of all these different ways of titling your property really varies state to state. So it's quite state specific, and the laws for each state are very particular when it comes to each style of titling your property. So for example, the way you title your property in California, if you have title in the name of joint tenants in California, that may be significantly different as far as its legal meaning if you have a joint tenancy on a property in Texas, for instance. So Jim, these are the most common ways that I see property being titled. Can you go over these different ways of titling property?
Yeah, so I'm going to give you about 6 months of law school real property in about, 60 seconds. Individually, I can own a piece of property. Jim Cunningham, owner of the property, and in the United States, you own the property to the center of the earth, meaning if you own an acre of land in California, it's square, you own that land all the way to the center of the earth. And that is a unique piece of land. You own it, it's yours, and that is called a fee title, F-E-E. So that's from, Middle England a long time ago, but you can own it as an individual. So our country is based on the concept of private ownership of property. That is not the case in many other countries, okay? So in many other countries, you don't really own the land. It's some type of other arrangement, but in the United States, you own the land. Now, you can own that individually. That means just your name is on the title. And by the way, when you die and your name is on title to property, that's when probate kicks in. So if that acre is worth $1 million in California, the probate fees are over $50,000 on that one piece of property. And that just gets it to the next person. Because you can't take it with you, right? So when you die, you can't take this stuff with you. That dirt is going to stay there all the way to the center of the earth. That dirt's going to stay there. So if Jeff and I go on title to property, the two of us, who owns the property? That's a really good question. Well, we both do. Well, what does that mean? Well, joint tenants, and we'll talk about what joint tenants is. That's when more than one person owns the property and they have an equal portion. So Jeff and I, if we're joint tenants, it has to be 50-50. It can't be 80-20 or 10-90. If it's joint tenants, it is an equal portion of the property. That's what that means. It's almost kind of like a partnership. Joint tenancy in California means last man standing gets it. So if I die, Jeff gets the property. My wife doesn't get anything, right? She's not going to be happy with that. Community property, only married people can own community property in the state of California. Now, in the state of California, marriage, spouse, is the same as registered domestic partner. So California has a registered domestic partnership law that gives parity or equality between spouses and registered domestic partners when it comes to items like community property. So community property can only be owned by people who are married, and that's the joint property, the marital property. Separate property is if I'm married and I bring that acre of land in California to the marriage, that is my separate property. And so we'll talk about that in a little bit as well. So that's my separate property. And I will tell you, it is very easy for a property to go from separate property to community property. That's a super easy, slippery slope. It is almost impossible to inadvertently go from community property to separate property. Okay, that has to be a very intentional act. And then, of course, trusts. Most of our clients, and I recognize a lot of names on the attendees, have set up revocable living trusts. And that's the other big way to hold title in the state of California. So
Now,
we're not divorce lawyers, but I will tell you, this is kind of a tricky area of the law. And so what happens at death? Okay. Well, what happens at divorce? So people get married, they bring property to the marriage. They then may acquire property during the marriage. Title is evidence, not definitive proof of ownership in a divorce setting. Now, let me give you an example. I'm married and I use my earnings to acquire property in my name solely. That property is only in my name. It is not in my wife's name, but I've used community funds to acquire the property. That means that the community being half me, half my wife, the community acquires an ownership interest in that property. And in this case, even though it's in my name, it will be treated as community property for the purposes of divorce. However, death is different. And this is actually kind of a mistake in California law. It's a case from the 1980s that the state legislature hasn't really fixed. Title controls at death. And that's something that we as lawyers say, if that property is just in my name, titled as my sole and separate property, that title controls, and that is distributed however my separate property is distributed, whether it's my will or my trust that distributes it, that property title controls. Now, my wife can go to court. She can go to court and seek her portion of the community property, but that requires a mini probate proceeding where she goes to court and she proves it up. So as we say, title controls at death. But if she wants to assert her community rights on that property that's titled solely in my name, she's going to have to go to court to do it. Property acquired during marriage. This is very important. Property acquired during marriage is presumed to be community property. Now, what does that mean? That's a presumption. The courts will assume that the property acquired during marriage is community property. The exception, the carve-out, is property that you bring to the marriage, that you acquire by inheritance, or you acquire by gift. So somebody dies and you inherit the property, or someone's still alive and they give you the property, that's titled in your name. The presumption is that that is separate property. It's only a presumption, right? And your divorcing spouse has the opportunity and the right to attempt to prove that even though that property was in your name separately, that you said something or you spent the money in a way, or something else happened in the relationship that would cause a judge to rule that, and it's a judge that decides it, that would cause a judge to rule that separate property is actually being community property. So we've got a real, a really big issue here for people who frankly get divorced, and that's a 50% probability getting divorced. Death, I've heard it's 100% probability, although I don't really believe that myself. I think I'm the exception to the rule, but this is a conflict between what you want, what the law is, and what the title is.
Yeah, absolutely. So this is just a really quick diagram here. And Jim, I think you kind of already touched on this, but what happens with a lot of people is they acquire title to a piece of property. And a lot of people will acquire property before they actually have some kind of estate plan. The natural progression of people is they buy a piece of real estate, years go by, and then maybe they meet with an estate planning lawyer, and eventually they transfer that property to the trust. So there's this window of time where you own real estate, which could be your most significantly valued asset. And the only person you really talked to was a real estate agent when you acquired title, right? And they may have said, well, you were closing escrow and you had to answer, how are you going to take title to this property? Well, you probably looked at your real estate agent and the agent probably said, well, just put it in joint tenancy. That's what everybody does in California, right? And then maybe you'll meet with a lawyer and transfer it to your trust. But there's this window of time where there's an opportunity for a bunch of things to happen to title of the property. And if you're not working with an attorney to guide you on this really from the outset, you could really put a cloud on title that's difficult to reverse and could cause some significant issues for you if you do get divorced, if you're married, or when you eventually pass away. So a lot of what we're going to talk about today, Jim, is really focused on issues that exist for married people, because that's where a lot of the gotchas exist, especially under California law, because we are, as you mentioned, a community property state. So you had talked a little bit about what happens at death, where title controls what happens at divorce, where there's a presumption of community property. But let's talk a little bit about what happens at death here. So you have a married couple and they acquired title as joint tenants, and one of them passes away. And on the deed, it says joint tenants with right of survivorship. So this is something almost everybody I meet with comes in and they say, what does that actually mean? What does right of survivorship mean in California? Well, interestingly, the phrase joint tenants or joint tenancy in California is implied that there's a right of survivorship. So essentially what that means is if there are two people who own the property and they own the property as joint tenants, if one of them passes away, the survivor owns 100% of the property. It's the survivor's right of survivorship, essentially. So interestingly, on a piece of California real estate, if it's titled as joint tenants, it doesn't need to say right of survivorship. It's actually a redundancy if you see that on the deed. So imagine one spouse passes away, the other spouse is still alive, and they own it as joint tenants. What does that actually mean? Who owns the property at this point? Well, if they own it as joint tenants, there's a right of survivorship. Now this causes several potential problems, but the two biggest problems that we see come up regularly is, number one, if there's a blended family, right? If this married couple were on their second marriage and they each had kids from their previous marriage, well, what happens when that surviving spouse simply owns the house 100%, right? Is there any guarantee that that spouse is going to leave a portion of that property to his or her stepkids? No, there's no guarantee. And what most likely is going to happen is they're going to arrange to leave that property to their kids. Now, I'm not saying every family does that, but frankly, that's what I see happen quite frequently. And a lot of people say, hey, I got a big problem with that. Some people say, well, hey, what do I care? I'm fine leaving this property to my spouse. But with blended families in particular, this is really something you got to pay careful attention to. Now, the second problem that we see come up with property titled as joint tenancy is when the first spouse passes away, there is no probate. There is no need to go to court to acquire title to the property. Joint tenancy already means that the surviving tenant owns the property 100%. But if that surviving spouse never touches the title and he or she ends up passing away down the line, what happens then? How do we know who owns that property? Well, we don't know, right? And then that property gets exposed to what we call probate court. And there's a big court proceeding that usually lasts about 1.5 years in California and costs tens of thousands of dollars to determine who's entitled to the property. So that's a big problem with joint tenancy. A lot of clients I meet with, Jim, they say, well, hey, you know, our property's in joint tenancy. We don't really have a problem with probate, right? When one of us dies, there won't be a probate. That may be true, but when the second spouse passes away, if you leave title that way, you've now caused a big, expensive probate for your family.
Yeah, another
and with proper estate planning. Yeah.
Another overlooked
issue,
Jeff, I'm really glad you're mentioning this. Another overlooked issue is incapacity. So this is where you have two spouses, and let's say the husband has a stroke and the wife is caring for the husband, and they need to sell the house. Without any estate planning in place, joint tenancy does not give the wife, in this case, the ability to sell the house. The husband's going to have to sign the documents, but if he's had a stroke and he's out of it and he's in a nursing home and they need to sell the house to pay for that care, the wife is going to have to go to probate court and file a court petition to be able to sell the house. And it's very, very important. And those court petitions kind of start out of the gate at about $10,000, $15,000 or so. It is also very common for clients to have a trust, to put the property into the trust, and then for many reasons, take the property out of the trust. And the biggest example is when people refinance a house. You know, real estate or mortgage rates are now, I think, at record lows right now. So very, very low interest rate. For those of you who have a mortgage, and it may be at a higher rate, many people are looking to refinance those mortgages, and many lenders will require you to take the property out of the trust. So it's very important if you refinance property. So when you when you're thinking about this and you say, yeah, well, we refinanced our house a couple of years ago, you really want to verify that your property is inside of the living trust, because if it's not inside of the living trust, it is potentially a big problem.
Yeah, and Jim, I actually got a call from one of our clients yesterday who said, we're doing a refi and the lender's telling us we have to take the property out of the trust and then put it back in the trust. What on earth is this? Is this legitimate? And I'm glad you addressed that. And that is an issue when they put the property back into the trust, for example. Sometimes things get overlooked, or sometimes it's not put into the trust at all.
And you need to be very extremely careful. If you value Prop 13, and we'll talk about this at the end, if you value Prop 13, you have to be very, very careful when you start transferring property, because I will tell you guys that the State Board of Equalization over the last few years, and Jeff, you've seen this in the time that you've been a lawyer, the State Board of Equalization is really cracking down on counties because not all the counties were following all the Prop 13 rules. I mean, you know, it's actually kind of hard to believe that the local counties weren't following all of the state's rules, but they weren't. And so the State Board of Equalization has really been cracking down, typically the smaller counties, not so much Los Angeles County, the Bay Area counties, but the more remote counties, the more rural counties, the Board of Equalization is really cracking down on them. And believe me, the state of California would love to get rid of Prop 13, okay? And that's on the ballot this fall, is to take away Prop 13 for industrial and commercial properties if the entity that owns them has more than 50 employees. So something to be really mindful of. Anyway, go on, Jeff.
Yeah. Well, Jim, I'm going to ask you a loaded question here, and that is, I'd like you to go over this example of what happens with jointly owned property at divorce and how we determine who owns the property.
Well, so in the interest of full disclosure, I became a lawyer 26 years ago, and my dad was a lawyer. He was a family law attorney at the time, and he said, Jim, don't ever handle a family law case. He was a very caring kind of person, and I think took a lot of the emotional baggage home with him. Which is not so good. We do have one quick question here. Jay McCoy asks, how can I verify the house is under the trust after a refi? What we do internally is we reach out to third-party data providers and we pull out the last recorded deed. So that's how, or not necessarily the last recorded deed, but we go back, maybe it might take a couple of deeds if you have a note or a note secured by deed of trust or deed of trust recorded, or other, you know, security interest recorded. but we can pull that from public records. So Jay McCoy, great question. And that's something that we can help you guys with. So issues for married people. What happens in divorce? Okay, a single person owns a property, then gets married. So I'll just use my example. I buy a piece of property before I get married, then I get married, and I don't add my spouse to the property, just my name is on the property. I then, with my earnings, with my labor, by the way, your earnings, your capacity to earn money is considered a community property asset, okay? Unless there's a prenup, unless there's an agreement to the contrary, California law has the default, the sole default is all property acquired during marriage is community property. What is interesting is we have a client who's French, and the French system, you can opt out of community property by checking a box, which is very French, right? On your marriage documents, you check a box and everything's separate. Okay, so that is not our system in the United States. So I make money. You know, I'm working in the law firm. I'm taking a salary, and I pay the mortgage. I pay the mortgage. What happens? Who owns the house? Well, I'm on title to the house, but I don't necessarily own all of the equity in the house. Okay. So because I'm using my earnings during marriage, it is property that is acquired during marriage that goes from my bank account. Maybe it just has my name on it. It goes from my bank account to the house that's just in my name. But because I'm married, those earnings are community property. So there are two cases. Well, there's one case, the Pereira Van Camp is a body of law. That's case law in California that figures this out. So what ends up happening is every month that I make a payment on the mortgage principal, the community, my wife and I, the community acquires an ownership interest. So if the property's worth $100,000 and I make a $10,000 payment on to reduce the note from 100 down to 90, okay, I pay that 10,000. The community owns 10% of the property. So if the property goes up to 200,000 in value, that community interest isn't 10,000, the amount I paid, but it has a proportional interest in the property. So now it's $20,000. And then that's split 50-50 with my wife and I. So at divorce. So what this stands for the proposition, and this is very important. Here's the key takeaway. If you are married and you use community funds to pay a mortgage down, the community owns, with every payment, they own a fractional interest of that property. So as the property goes up, the community interest can be beyond what the dollar amount was that was paid for that particular interest. So very complicated. There's actually a program called DissoMaster for those of you who have been divorced. It is a computer program that the judges use, all the lawyers use it. They put in all the data and they tell you, okay, you brought the house, you brought this property to the marriage, it's worth 100,000. At divorce, it's worth 200. You paid down $10,000 at these various intervals, and it does a big math calculation, and it says this is what the community is entitled to, and then that community is split 50-50 between the divorcing spouses. Now, what happens if we don't get divorced? What happens if I die and that separate property house, I leave that separate property house to my son? My wife has to go to probate court to claim her community property interest. Okay, she has to go to court to get a court order. If she doesn't go to court, my son inherits that separate property asset, and she loses her community property interest in that property unless she comes to me or comes to the court and says, hey, I want my half of the community property interest. So it's very, very important. Title controls. Yes, there's a court proceeding where you can make a claim on that property, but my widow, in this case, would have to go to court to make that claim. Now, if I don't have a will, let's say I die and I don't have a will and I've got 3 children, and I do have 3 children, my separate property is distributed 2/3 to my 3 children. So get your head around the math on that. So 2/3 goes to my 3 children, 1/3 goes to my wife. Now, You can get around that by doing a will. That's in the absence of a will. That's in the absence of a trust. So it is very, very important. Here's the big takeaway, especially if you're married. Please pay attention to the title on your real estate. It is very, very, very important. I did meet with a client, Jeff, I think it was about your age, years ago. And he had at the time with his partner a $30 million real estate portfolio, and it was all held as joint tenants with his business partner. And I told him, I mean, this is when $30 million was a lot of money. I'm kidding, because it was like 20 years ago. But I said to him, you know, your business partner's going to end up with everything, and your wife's not going to get anything. And he says, I know, but if he dies first, I get everything. So the door swings both ways on that. But bear in mind, title, absolutely super important.
Yeah, absolutely. And it's interesting that you brought up the disso master, Jim, because every single client I've met with, well, not every single one, but most of them, they usually come in after they've gotten divorced, or my clients who have been divorced come in and they say, hey, the disso master was so screwed up. They needed to run a new disso master, and I wasn't happy with the result. And but that's the way the judge signed off because of this silly software program. And don't leave it up to the disso master, folks.
Yeah, don't leave it to a computer program.
Yeah, really take control over what's going to happen, you know, in the event that one of these scenarios does come up. So one thing I'd like to go over are some of the common traps that we see people make. So I guess you can kind of say that everything we've talked about so far has been a trap that people commonly fall into. But one of the traps has to do with when you own property jointly. So this is a common theme we've been going back to and back to. So there are several ways that you can own property jointly with somebody, different ways you can characterize each person's ownership. So we have one way of owning, which is called joint tenancy, which we kind of talked about already. But there's another way you can co-own property with other people, and that's called a tenancy in common. And we haven't mentioned this one yet. So what's the difference between a joint tenancy and a tenancy in common? Well, they're very similar in that with both of those types of titling, each owner of the property may occupy the whole property, right? So I co-own property with my brother and my sister. We all pitched in to buy this property. Whether we own it as joint tenants or tenants in common, we can all decide to live in the property.
Wait a minute, Jeff, are you talking about the studio condo in Santa Monica?
Yeah, and what on earth is going to happen when all three of us show up at the doorstep with our furniture and we're ready to move in, right? Who on earth is going to resolve that, right? We'll talk about that in a few minutes. But so they're very similar in that regard. But with joint tenancy, Jim, you mentioned this, each owner of the property who's a joint tenant has to own an equal percentage. So in order to have a valid joint tenancy, everyone has to take title at the same time. They have to own an equal percentage, and they have to have an equal right to enjoy the property as one another, right? With a tenancy in common, that's a bit different. So with tenancy in common, each co-owner of the property doesn't have to own an equal percentage of the property. So with me, my brother, and my sister on this property, if we decided to take title as tenants in common, and I paid a little bit more than my brother and sister, so we agreed that I would own 40% of the property, they would own 30% each, that can occur with a tenancy in common, right? Yeah, another distinction, but go ahead.
Yeah, and just one thing, this is, you hit a you bring up a very important issue. If you are investing with, and I've been talking to a lot of clients, they say, you know, the economy's kind of shaky. We don't know what's going on. It might be a good time to invest in real estate. Interest rates are low. Great. Okay. So I'm starting to hear that with clients. And many times people want to do a joint venture. Now, if you choose not to do an LLC, which is kind of outside of the scope of what we're talking about, to your point, Jeff, is if it's a 40-30-30 split and you go on as joint tenants, you're a third, a third, a third. You just gave up some equity. If you go on as 60, what were your numbers? 40-30-30, all as joint tenants, even if you write joint tenants, what the law will say is that is not joint tenancy. That is tenancy in common. Even if you say it's joint tenants, it will be treated as a tenancy in common. Probably no right of survivorship, although we're kind of getting on a slippery slope here. So it's very important to understand if you are bringing on essentially partners who are putting in different amounts of an investment, you're going to want to look at tenancy in common, probably going to want to look at an LLC, which is a way of, yet a different way of holding title, but very important to pay attention to the two. And I would say that's the single biggest distinction between joint tenancy and tenancy in common, is the varying percentages of ownership.
Certainly. And you know, I would second what you said about probably there being no right of survivorship. So a lot of people, they kind of have this assumption that there is a right of survivorship, and one person ends up passing away who's one of the tenants in common, and their portion, if they don't have proper planning done, ends up going through probate. And now the other co-owners are going through a probate to decide who's going to own that percentage of the property. And they may end up co-owning that property with a person who they don't want to co-own it with, right? It might be the kids of their sibling or the second spouse who they don't get along well with. So potential problems certainly can exist in that realm. Now, a life estate. What is a life estate? Because we've talked about a bunch of ways of titling property, and now we're seeing this life estate here, Jim. What does that mean?
Yeah, so this does come up. You know, we were talking about sometimes married people own property jointly. Sometimes married people, it might be a blended family, like a Brady Bunch situation, and they come to a marriage later in life. Maybe he brings his 3 boys, she brings her 3 girls. You see where I'm going with this? So Mike Brady, I do remember the Brady Bunch. Mike Brady could leave to, what was his wife's name? Jan? I don't know. Mrs.
Carol.
Brady. So Mike can own the property just in his name. And let's say, forget community versus separate property. Let's say it's Mike's property. Mike says, you know, I really want Carol to live in the house, but when she's gone, when she's dead, I want the property to go to my 3 kids. So Mike signs it, sets up, or just signs a deed over to her saying, Mike grants to Carol for her lifetime the house, remainder to the 3 kids. Okay? That is a form of joint ownership in the sense that you have divided ownership, but unlike a joint tenancy or a tenancy in common, where there's a present right for all of the people on title to occupy the property, only the life tenant is entitled to occupy the property. And this is very important. So only the life tenant is, in this case, only Carol is able to, or has the right to occupy the property. Certainly she could let the 3 kids live there, but she doesn't have to. She can also leave the property and rent the property and collect the rents and put it in her pocket. But when she dies, her tenancy, her holding of that property, that's what the word tenant means, a holder, her right to occupy that property, her rights to the rents, when she dies, that dies with her. And then the 3 boys, Mike's 3 boys, pop up, and now they own the property entirely. And Carol's kids don't own anything in that case. So I put this in here because a life estate, we do see in kind of homemade estate plans. Sometimes we'll see a life estate. It can really complicate things because if Carol's alive and one of Mike's 3 boys declares bankruptcy, what's the effect of that? Well, it may force a sale of the property, is the bottom line. So the bankruptcy trustee could force a sale of the property because Carol's right to live in the property has an ascertainable value at any point in time. We use the IRS tables and we say the value of her interest, her life estate might be 30% of the value of the property. So, you know, in that case, maybe a bankruptcy trustee could force a sale and Carol loses the house, but she keeps her 30% of the sales proceeds of the house. So I throw that in there. Life estates, we do not use them in the real world. I'll just tell you, in the real legal world of estate planning, we don't use them a whole lot. I mean, I can think, Jeff, I mean, maybe 3 or 4 instances where we've done life estates, and they tend to be on like mountain cabins or smaller properties. But it's not a primary estate planning vehicle. The other issue is who pays the expenses. So in this case, Carol has to pay the expenses attributable to income. Well, that would be the utilities. That would be, you know, paying the gardener. But what if the roof needs replacement? Well, that might be a capital expenditure, and that would be attributable to Mike's 3 kids, what we call the remainder people. So those 3 kids. So that sets up a potential problem with Carol and the kids, because Carol says, well, I don't want to replace the roof because I'm 80 and I'm not going to, you know, I'll live maybe 20 years, but I'm not going to get the full use of that 50-year roof. So I want the boys to kick in on a little bit, and then becomes dicey. So that can be a bone of contention, paying the expenses. And so we highly recommend, if you are going in your estate plan, if you're Mike and you want to have Carol live in the property for her lifetime, and then whatever's left over go to the kids, his kids, we really need to flesh out who pays for what. And so it's important to have clarity in your estate plan versus having it kind of murky and unclear. And then you have problems, and then, everyone lawyers up, and the family's not having Thanksgiving together ever again. So I think the whole point of estate planning, Jeff, as we say, is you want to write your estate plan in a way where your family will want to get together at Thanksgiving and not want to never see each other again.
Yeah, and I'm glad that you kind of related this back to estate planning, because we're talking about things that are potentially problematic, but what we want to drive home is these problems are all solvable, right? We're not looking at things from the standpoint of, hey, this is going to happen and this is going to happen and it's all going to fall apart. We look at these problems because we're identifying issues so that they can be solved before they become issues.
All right, so we have a couple questions here. Anastasia Schbach says, what's the preferred for a married couple, joint tenancy or tenancy in common? What are the pros and cons of both options? I think it's an individual basis. I would say we see more joint tenancy, less tenancy in common. But I will say, just generically speaking, when clients come in and they have joint tenancy property, they own real estate, we typically recommend that they do a living trust, because a living trust does one very important thing for Californians. When one spouse dies, the other spouse can sell all the real estate and not pay capital gains tax. So when one spouse dies, the other spouse can sell all the real estate and not pay capital gains tax. That is not the case if it's held as joint tenancy. Okay. So it's very, very important to be mindful of all of the issues. And this is why you want to meet with an expert lawyer. Our firm, all we hire are expert lawyers. We are top in our field. Jeff took and passed the certified specialist exam, and he's in the process of getting fully certified. Been a certified specialist for over 10 years. So this is not an area for amateurs. This is not an area for non-experts. But I would say, generally speaking, we would do a living trust. Then Hilda writes, if you have time, please talk about the best way to title property where the parents pay the deposit and any part of the monthly payment, and the child makes the rest of the monthly payments. Yeah, so typically we would structure this as, so what I'm hearing is that the parent helps with the down payment. So typically, so let's take an example, just to make the numbers easy. I don't know that there are many $100,000 properties in California, but let's say the property is $100,000 and the parents are lending 20%. So the parents are going to lend $20,000. What we would typically counsel our clients to do is to lend the $20,000 down payment and take a note secured by a deed of trust, which is a mortgage in California. So California has this deed of trust system, and I'm not going to get into the complexities of mortgages versus deeds of trust, but the bottom line is the parents should maintain their status as a creditor. And here's why. Number one, it might be a gift and potentially cause you to file a gift tax return. Secondly, that if the spouses, if you make a gift to your child and presumably their spouse, and they get a divorce, that future ex-son-in-law or that future ex-daughter-in-law will get half the gift. Now, probably 95% of the time, they don't deserve it. Although I've had some clients, they come and they say, yeah, my son was a total jerk, and his ex-wife, we love her more than we love our son. But, by maintaining that debt structure where the parents are lending the money to the son and the daughter-in-law in this case, that protects the parents' loan, quite frankly, so that if the house is sold in a divorce, the parents get their money back. So that's typically how we counsel most clients in a situation like that.
Yeah, those are all really good questions. So we're going to shift topics here. We're going to talk about another way people end up acquiring title to property, and that is through an inheritance. And when it comes to an inheritance, there are really two significant ways that you can leave an inheritance to somebody, or that a person can receive an inheritance. And number one is called an outright distribution, and number two is in what's called a continuing trust. So what I would say traditionally, historically, when you think of an inheritance, most people are thinking of an outright distribution. you pass away, the person who inherits becomes the outright owner of that property. They own it in their name and they do whatever they want with it, right? Now, that could become problematic if that person is going through a divorce or a bankruptcy or a lawsuit. There are several reasons why there's been a kind of a shift from people leaving things in an outright manner to leaving them in a trust that continues on after you pass away in order to protect that inherited property from that. But we're going to go over 3 case studies here, and we're going to kind of highlight how a person receives an inherited property impacts what happens with that property if they get divorced or if they pass away. So we have our first case study here, and this is Bob Jr. And Bob Jr. inherits mom and dad's house. And Bob Jr. is a nice guy. He's in a good marriage, but he receives the property outright. So the property simply goes into his name, right? Bob Jr. is now the owner of the property when he receives his inheritance. And frankly, if that's the case, there's no protection, right? So when you're married, and Jim, I think you mentioned this at the beginning of our presentation, but if you're married, there's a presumption that assets you acquire during the marriage are community property. A big exception to that rule is if you receive an inheritance while you're married. That starts if you put your spouse's name on title, for example, or if you put them on as a mortgage owner, or if you start taking community property assets and you pay off a mortgage or a second mortgage on that property that's your separate property as an inheritance, that commingling actually results in a change in the character of the property. And a portion, if not all, of that inherited house that started off as separate property could actually become community property. And so if Bob Jr. and his spouse get divorced after commingling those assets for years, what happens to that inherited property that Bob Jr. got? Well, if it's community property, folks, they split it 50-50 in the divorce, right? Bob Jr.'s spouse walks away with half of that property that frankly should have been Bob Jr.'s. And that results, frankly, because that property was left outright. It almost invites commingling to occur. And frankly, if you live in California, or if your children or whoever you're going to be leaving property to live in California, it's almost as if California lawmakers have drafted the laws to where they want property to be considered community property. So it becomes very easy to inadvertently change the character of your separate property into community property. And unfortunately, a lot of people become unpleasantly surprised when their spouse has an interest in the property upon getting divorced. Now, let's look at another case study here, and this is Vanessa. And like Bob Jr., Vanessa also inherits mom and dad's house when mom and dad pass away. But what Vanessa's parents did, rather than leave it to Vanessa outright, they created a provision in their trust that provided that when mom and dad pass away, the house goes into a trust for Vanessa's benefit. And Vanessa can be the manager of that trust. She can control the property. She can have access to the property. But the fact that that property is owned by the trust that was set up for Vanessa's benefit, it significantly protects the property. It prevents that property from being inadvertently changed to community property. Now, it doesn't make it impossible for this to happen, but it provides a level of protection from this happening inadvertently. And what happens with most people is they inadvertently commingle those assets without really intending to do so. With a continuing trust, mom and dad basically say, Vanessa, look, we trust you to manage this property and enjoy the property and benefit from it. But we've realized that, you know, the rate of divorce is so high, your marriage might be going great while we create this estate plan, but after we pass away, who knows what will happen? I know plenty of people who have gotten divorced after 20 or 30 years of marriage. It happens, right? And this is a way to protect the property. So if Vanessa ends up getting divorced, she retains 100% ownership of that house within the trust. Anything you want to add there, Jim?
No, I mean, this is great. I mean, this is for, you know, many of our clients, probably 80% of our clients choose to structure their estate plans in this way. And in this case, Vanessa here, she's a very responsible, professional person. It's not like she's an irresponsible beneficiary. So we're not talking about a protective trust because somebody's irresponsible. What we're talking about, frankly, is asset protection. Because I can tell you guys, my friends, I'm at the age now, I'm 51. And about 10 years ago, my wife and I looked at each other. We said, man, not hardly any of our friends have gotten a divorce. Now, a whole bunch have gotten a divorce, right? In their 40s. And these people have been married 15, 20 years. And, it happens. And, our goal is to make sure that the legacy that you've created over your lifetime is preserved for the people that you care about, quite frankly. And it's not going to future ex-son-in-laws and future ex-daughter-in-laws. So even this very responsible person here, Vanessa, we do a continuing protective trust to protect that asset from divorce or other potential, you get in a car accident that's not your fault. You might be 1% at fault, but guess what? You're responsible for 100% of the medical expenses, okay? And medical expenses, as you know, can be millions and millions and millions of dollars. So very, very important, and I'm really glad you brought this up, Jeff.
Yeah. Now our third of 3 case studies here actually is based off of a case, Jim, that you recently handled.
Yeah.
Why don't you go over this one?
Yeah. So this is kind of a weird one. I had a widow come to me, and in this case, Phil. So Phil dies. Okay. So a lot of people die in our examples because, it's estate planning, I guess. But so what Phil does is, Phil dies, but before Phil dies, his wife has $25,000 in credit card debt, and they're entitled to the property. Phil and his wife are entitled. So the wife is really concerned. Hey, I've got this $25,000 credit card debt. This is actually a real case. These were, it's a family originally from Ukraine, which is close to Russia. And my wife and I, we adopted our 2 daughters from Russia 15 years ago. So I'm sitting with her, and she says, well, I transferred title to my husband as his sole and separate property because I was worried about this $25,000 credit card debt. Well, he died of a heart attack. He was like 37. Died of a heart attack while driving a truck. So here's what I had to tell her to Phil's widow. You only get 1/3 of the house. Your children get 2/3 of the house because Phil, your husband, died without a will. And so what this means is, and remember we said title controls. So she's going to have to wait till the kids are 18 to do anything with the property, until the last kid turns 18. Otherwise, she's going to have to go to probate court. She'll either have to go to probate court to prove that was really her community property, which is tough because title controls. And also she was the one who signed it over, right? So it's a little bit different if he was kind of doing this on his own, but she's the one who signed the deed, transferring it to Phil, and Phil later died. So this is a really, really difficult case. And my advice to her was basically wait till your kids turn 18 and then deal with it, because it's literally tens of thousands of dollars to sort it out. And it's not, the house is a $250,000, $300,000 house with a mortgage on it. So very sad case. Again, this kind of highlights the importance of please have even basic estate planning like a will, or better yet, a living trust for most people, but very, very important. And this is a case where title controls.
And just one other thing on this example, because I meet with plenty of people who decide they want to transfer ownership of property to their kids, or they want to co-own a property with their kids. And a lot of people do this, whether it's a cultural thing or just something that people want to do. If it's not properly structured, it potentially creates a lot of problems. And a lot of people are surprised to hear that, because here you're doing something that's a noble endeavor, right? You're helping your children acquire a house. You're contributing to, the place they're going to live, and you're inadvertently creating a problem that may have to be unwound in the future.
Yeah. So a question, Anita asked a question on Phil's case. If he had a trust, can she transfer into the trust and preserve 100% instead of 1/3? Absolutely. So Phil could have written an estate plan like the trust for Vanessa, and he could have left that house to his wife in a continuing trust for her benefit. So she has 100% control, but it's protected from creditors. So absolutely. And then we have another question up here that we're going to save for the end when we talk about taxes.
Yeah, so actually that's pretty timely, because let's move into the tax discussion here. Yeah, so Uncle Sam wants more taxes, folks. And if you're like most of our clients, you probably pay enough taxes, right? And actually, though. So one of the taxes that come up, so there are several taxes that come up when somebody passes away. There are income tax concerns, there are inheritance, also known as estate tax concerns, there are capital gains tax concerns, and there are property tax concerns. One of the big ones, Jim, that I know you're really an expert in is Prop 13. What happens with property tax when somebody passes away? Right?
Yeah, so I want you guys to know we've got looks like we've got 46 people on here. There's a ballot initiative in the November ballot. It's actually called Prop 13, which is very confusing. It's a ballot initiative that seeks to repeal Prop 13 for commercial and industrial properties when those are owned by entities with more than 50 employees. So there's a ballot initiative that seeks to amend the California Constitution that would strip commercial and industrial property of all Prop 13 protection if the owner has more than 50 employees. I would say for most people on here, probably doesn't apply to them unless you have a triple net lease. So this is really important. If you have a business and all those expenses are passed through on a triple net basis, and what that means is you rent the property, but then they pass through expenses like common area maintenance. They pass through expenses like property taxes. If this initiative passes, then you really need to look at your commercial lease because you may have a really, really big tax increase. Now, this is designed to target like Chevron and Exxon and Apple and Google and all these big companies so that they don't no longer have Prop 13 protection, but this will trickle down to individual tenants in commercial and industrial property. So that's something to understand. So what is Prop 13? Prop 13 is in 1975 or in 1978, the California Constitution was amended, and it capped the amount of property tax to 1% of the value of the property. And on average in California, it was about 2.7% prior to passage of Prop 13. It rolled assessments back to 1975. And the reason I mention this, many of our clients have property that they acquired in 1975, right? Or 1978 or 1980. And we have some clients, especially in the more urban areas, the Los Angeles area, Orange County, and Bay Area, they might have a commercial property worth $10 or $20 million that's assessed at $1 million or $500,000, right? Has a very low assessment, and it's saving literally, $150,000, $200,000 a year in property taxes. So Prop 13 says you can only tax property at 1% of its purchase price, essentially purchase price, plus up to 2% a year. So your taxes can go up 2% a year, but that is not based on the value of the property. That is based on the California Consumer Price Index. So it's not based on the value of the property, it's based on the California Consumer Price Index. Very, very important for many people. And so when does property get reassessed? Whenever there is a change in ownership, there is reassessment. And I have news for you. Death is a change in ownership. Death is a change in ownership. Now, there are many exemptions. If Jeff and I acquire title to property and I die and Jeff inherits the property and we're the original owners of the property, no reassessment, okay? Death of a spouse, no reassessment. Death of a parent where the property goes to the child, reassessment. Unless you file a claim for reassessment exclusion. Jeff and I own a property as joint tenants. I transfer my half into my trust. He transfers his half into his trust. That is potentially a reassessable event because you have to transfer the property from joint tenants to tenants in common. Okay. These are little gotchas that are in Prop 13. So very, very important to pay attention to this. The parent to child reassessment exclusion. Very important. That paperwork has to be filed within 6 months of death to avoid a fee. And if it's more than 3 years after death, you don't get it. So meaning you have to, so mom and let me give an example. We get a lot of clients coming in, they say, my parents died 10 years ago. I've been living in the property for 10 years. I haven't done anything. The tax bill still comes into my parents' name. I pay it. What's going to happen is one day the assessor's office will be notified that the parents passed away 10 years ago. There's going to be a supplemental unsecured bill. The property will get reassessed going back 10 years, right? And so there'll be a whole bunch of back taxes to owe. That can be avoided if you file essentially a claim with the county to not have the property reassessed. So if you're going to inherit property, you're going to leave property to somebody, pay attention to Prop 13. It's very important. Now, we had a question, and this is kind of going back a few slides. If the property is titled as joint tenancy by two individuals, not spouses, does it cause capital gains tax when one dies? How about this if the survivor dies? Okay, here's the rule. If each of them, the general rule is you only get a partial step up in basis. So if Jeff and I own property as joint tenants and I die, my half gets an adjusted cost basis. What that means is if we pay $200,000 for the property and it's worth $400 when I die, my 100%, my $100,000 value goes up to $200,000. My family can sell my half for $200,000 and not pay estate tax or capital gains tax. Or actually, Jeff can sell the property for $400,000 because of joint tenancy, because Jeff gets it. Jeff can sell the property for $400,000 and not pay tax on my gain, but his gain he'll have to pay tax, right? The same theoretically holds true for married people, although the IRS, well, since this is being recorded, that does not always happen when it's married people. But bear in mind that there is not a full adjusted cost basis as a general rule when you have joint tenants. So it is better if you are married. It is better to own it as community property for an adjusted basis reason, but there might be other reasons why you don't want to have it as community property. That being said, if people aren't married, then you're only getting a partial adjusted cost basis. There are some limited exceptions, but as a general rule, that's the general rule.
Yeah, and if you're listening, you may have heard of something called a double step-up basis. A double step-up basis generally refers to when two spouses own a property as community property, or they own it as trustees of their trust, but they can substantiate that it was community property. What happens when one spouse passes away is both halves of the property are entitled to a stepped up or an adjusted basis. So very different than with joint tenancy, where only the half of the person who passed away is getting an adjusted basis. So that's what a double step up basis refers to.
And then the question is, can we avoid tax with the first right of refusal? I'm not quite sure what that means. I don't know if it's Prop 13 reassessment or if it's capital gains, but generally the tax workarounds, I'm not familiar with the tax workaround involving a right of first refusal.
Yeah. So Jim, you did a fantastic job at fielding the questions, but I think what we're going to do now is let's open it up for a Q&A, and then we'll conclude after we get your final questions in. So I encourage anybody to type in your final questions, and we'll answer them the best we can. And we
do have some upcoming webinars, some additional webinars. I don't know if you want to share that with them. Let's see.
Yeah, certainly. So let's see. I want to do this without ending my share screen.
You got top 10 estate planning mistakes with Tasha, which is a great refresher. If any of you guys are sort of like looking at your estate plan, like, is it up to date? And I will tell you, you know, with this, we're in the middle of a dialing back of the COVID reopening. We're kind of going back into like a second beginning of shutting everything down in California. We are starting to get calls of young people who we got a call yesterday. 45-year-old gentleman passed away with an 8-year-old kid, died of COVID. So it's real and it's happening. It is very, very important that you have your estate planning documents, especially your healthcare documents, at the ready. So if you go to the hospital for anything, and forget COVID, let's say you have a heart attack and you go to the hospital. Let's say you have a stroke and go to the hospital, or you fall and you break your hip. No one is going to be able to see you in the hospital. I don't know if you guys know this. They're not letting anyone in the hospital except the patient. So it is very difficult to do, you know, typically, you know, pre-COVID, we were able to go to the hospital many times and sign documents. So, you know, not necessarily deathbed planning, but, you know, people are in the hospital for an extended period of time. Those days are over. It's not happening. So you need to make sure your stuff's updated. You absolutely have to make sure that the people who you have named to make healthcare decisions for you or property decisions know that you've named them, and make sure that they have copies of those documents so that they can help you out. So Anita asks, can percentages of ownership in the case of tenants in common be 50-50? Absolutely. They can be 70-30, they can be 50-50, they can be 51-49. Absolutely. Tony asks, is there a fee to be paid if Prop 58 petition is filed 7 months after death? Yes, I believe it's $180 per parcel. And by the way, it is a race to the assessor's office. This is a claim, like a gold claim in the gold rush, right? This is the individual child, the individual or sometimes grandchild, right? Sometimes there's a grandparent to grandchild exclusion if both parents have passed away. It is the first one who gets to the assessor's office and files the claim. Amir asks, so did I understand it correctly that if a property is in a revocable living trust and I die, my wife can sell it and pay zero capital gains taxes? Yes, with a properly set up estate plan. That's the one qualifier. In your case, I don't know, but it would be something I would highly recommend that you reach out to us, and Jeff can do a review of your estate plan. Anonymous asks, so the best way to title property for a married couple is joint tenancy? Not sure. There's joint tenancy. There's community property with right of survivorship, which we haven't discussed. But joint tenancy is not community property. And this is something to understand. Joint tenancy is not community property. It's something else. Community property, if you are using community funds and you are married and you do not have a living trust, I would look really closely at community property with right of survivorship. That gets you the adjusted cost basis, where you can sell the property without paying capital gains tax, and it gets the property to your surviving spouse. Sick, right? That person could be incapacitated or pass away before they set up an estate plan. But I would look at community property with right of survivorship before I would look at joint tenancy. And then Steve, and again, this is not legal advice. The disclaimer at the beginning, I'm giving you my 26 years of experience, essentially my thoughts. Steve asks, if a property is inherited via a trust, not outright, what is necessary to avoid commingling? If you pay expenses out of regular income, does that result in commingling? Wow, there's a lot in that question. I will tell you that no two trusts are alike. So there is a like a statutory form advanced healthcare directive. There's a statutory form will in California. What this is the legislature said, here's an example of a will, fill in the blanks. It's very rigid and it doesn't fit a lot of circumstances. There's nothing like that for trusts. So there's no statutory default of a trust. So I would say this is a tough one, Steve. And again, I would have you call Jeff and go over your individual situation. If you pay expenses out of regular income, does that result in commingling? Probably, right? I'm assuming this is your income. Corazon asks, I have my house in the name of my revocable trust. I have two sons as equal beneficiaries. One is married, the other is not married, but has a daughter. What happens after I die? Well, it looks like it depends on what your trust says, but if it goes to the two of them, oh, this is really interesting. Who gets the house? So both of them can become tenants in common. And if one buys out the other, there's going to be a partial reassessment. So I don't know, Jeff, if you want to talk about, well, here's a classic problem. Mom dies, there's a house worth, to make the example easy, there's a house worth $1 million. That's the only asset in the estate. And the property goes equally to the two sons. One son wants to buy out the other son. If the one son buys out the other son, half the property will get reassessed. Half the property will get reassessed. What needs to happen is the trust needs to borrow money, which is a lot harder than it sounds because banks lend to people, they don't lend to trusts. That's typically a hard money loan. It's very expensive money. That money, the trust goes out into the market and borrows money and distributes the cash, the $500,000 to the one son and the $1 million home with a $500,000 mortgage to the other son. That's how you avoid reassessment. All right. So if you kind of got that, that's okay. But Corazon, you might end up in the real world. I think you could end up with at least a partial reassessment. I think it's a great opportunity. You need to schedule a time to talk to Jeff. And how do they do that, Jeff? Is there a slide that shows them how to do that?
Yeah, so there is no slide, unfortunately, but what you're all going to receive after this webinar ends is an email to the email you used to register with an invitation that you can click and easily set up a free, no obligation consultation with me. You can also go to our website, CunninghamLegal.com, and you can also go to our Facebook page and book an appointment that way.
Does joint tenancy, an anonymous attendee asks, does joint tenancy for a non-spouse individual need to go to probate if one dies? No. If there are two people on title, and is in California, if it's joint tenancy, last man standing or last woman standing gets the property, right? Jane asks, if you are getting remarried and your fiance is using his prior house sales proceeds to purchase a new home, is that considered commingled at the point, or is that his separate property? Should title be community property to protect non-contributing spouse, or best to own it in a trust? Jan, only married people can own community property. So if you have a fiance and you are not married and you purchase a property together, you are treated as essentially, it's like a joint venture. The default legal mechanism is probably going to be a partnership. And I'm really glad you mentioned this, because the fact of marriage alters your estate plan. So Jan, in your case, you can do all this planning, but when you get married, so you're engaged to your fiance, once you become married, that changes your estate plan. And what I mean by that is, a spouse, if you have an estate plan and get married and don't change your estate plan, your surviving spouse is what is called a pretermitted spouse. Pretermitted spouse. That's a Latin word, okay? All that means is a forgotten or an omitted spouse. They are entitled to a portion of your estate outright, okay? So it's very important. The fact of marriage does alter your estate plan. Jan, I would highly recommend you set an appointment with Jeff and just go over the fact pattern and get a game plan together, because you know what? We say that when somebody dies, everything sees the light of day, right? And you're going to have people come out of the woodwork. And this is when you're gone, right? People are going to come out of the woodwork and they're going to be divvying up the estate, and what the law is and what you want. Oftentimes those aren't the same thing. Anita asks, if a deceased parents die with a trust, 4 children, is it best to set up 4 trusts with instructions within the parents' trust for each child instead of distribution, and let each one figure out their personal desire with any assets? Absolutely, Anita. That's such a great question. That's typically what we do. So when you have a trust and there are 4 beneficiaries, this big trust, we have 4 like seeds, right? That like acorns. And that when you die, those acorns grow into oaks and they're their own trust, okay? So these 4 little buckets, you put money in each bucket, and let's assume the 4 are like Vanessa, successful, well-adjusted, great people. Each of these 4 people, they can be the trustee of their own trust, okay? And then they decide what happens, but it's protected. So very, very important. I'm really glad you answered that question. Corazon says, thank you. It looks like we're over an hour. Okay, you guys, boy, we've got some diehards here. I really appreciate you guys sticking around. I need to ask, how long can couples live together before they're considered common? California has no common law marriage. It's very important to understand. I think Montana does, and that may be the last state that has common law marriage. But California, there is the Lee Marvin case, Marvin versus Marvin, that has to do with support of unmarried people. So even though there is no common law marriage, there are some issues that come up in divorce. But very important to understand, death, totally different than divorce. Completely different than divorce. If you have a partner and you are unmarried and you were not a registered domestic partner, there's nothing there. I have a good friend who was engaged to a very wealthy person in Napa. And I think he had about a $50 million estate. They were engaged. He died. She got absolutely nothing. And that is not what he wanted. So very important to pay attention to that, especially if you are unmarried. And we do have a fair amount of unmarried clients. So there's one area in Nevada County that is kind of a bunch of hippies, basically. And I went to UC Santa Cruz. I'm actually wearing Birkenstocks right now. But a lot of people not living a traditional married, couple lifestyle. These are people who are cohabitating. They're life partners, but they're not married. They're not registered domestic partners. very important issue, and that's something to be that is actually more complicated than marriage. So it looks like, Jeff, we've got our upcoming webinars here.
Yeah, I just wanted the folks of you who are still in attendance, which honestly is all of you. That's fantastic. I encourage you to look on our website. This is our upcoming calendar of webinars. You'll see we have a lot of content coming out. Some of these are unique topics we've never spoken about before. Some of these are more general topics that we have previously done a presentation on, but we encourage you to tune in if you've never seen it. And Jim, I just want to say that was really a fantastic lightning round you just went through answering all those questions. That was really impressive. You deserve a break after this. So.
Well, I do want to say,
folks,
listen, before we go, the two ones that leap out off the page to me are Passing the Torch, a workshop for you and your adult children. Super, super important. If you have adult children and they're involved in your estate, I really think this is extremely valuable content. And you know what, the one silver lining in the whole COVID thing is we're doing so many of these, and I think it's a great opportunity to learn. The next one is right after the Passing the Torch. That's the July 29th webinar. We have a very high-level person from John Hancock Institutional. What that means is John Hancock, the insurance companies own some of the biggest properties in the United States. They're some of the biggest investors in the United States. We've got a really special guest. He's going to go over third quarter overview. So third fiscal quarter. So if you care about your money and you're in investments and real estate and anything like that, you're going to want to check that out. And Marcia, hey, Marcia, great to see you. Thank you both. Thanks for attending, and thank you for your thank you.
Yeah, so I think, guys, what we're going to do is we're going to take this webinar and our presentation, we're going to upload it to YouTube probably. So if you couldn't catch everything we talked about, you can catch it on there. You can also feel free to call us or frankly make an appointment with us for a free consultation. It's not every day you get an hour with a lawyer for free, but that's what we're offering. And I encourage you guys to take us up on it. So Jim, without further ado, I think let's wrap this one up. Let's get it on YouTube. Thanks for your time today, everybody. And
all right, guys, thank you so much for attending today. And all right, we'll see you at the next one.
Bye, everybody.
You're preaching to the